I'm sure you know what a guarantee is. A guarantee is a document you sign that is guaranteed to bring you down. Because when you sign a guarantee, you are completely liable. So when you read a guarantee, when you negotiate a guarantee, you have to limit your liability. The bank will hand you a guarantee that will say that you will pay. Your bank guarantee says literally, if a bank employee gets into an accident going to the closing and is sued for $1 zillion because the employee was drunk, you have to pay the bank. Because the guarantee says that you will indemnify the bank for any liability whatsoever. The guarantee says that you're in default if you're disabled and that they can call the loan in. So when you sign a guarantee, 10 people sign guarantees, they're each 1/10 of the deal, and then the deal goes down, and you're the only one who's still in town. But if that guarantee says that your responsibility will be limited to 15% of the problem, that's good. But then the boilerplate language beyond that says that you're still responsible for 100% of the bank's attorney's fees and costs. So, one thing I say all the time, especially when I talk to the younger lawyers, you have to read every word of every document. You can't just skim and pick the big stuff. If you skim and pick the big stuff, then under the Paredes principle, in 20% of the effort, you will spot 80%. But one thing that Hamden here has taught me is when you read every sentence of that document, that's where we hide the stuff, right? That Tom Waits saying, the large print giveth and the small print taketh away. That's what we're doing. One of you asked me earlier, do you have a note and mortgage form that I can use to loan money to my friends? Well, do you want the one that I use when I'm representing the borrower or the one that I use when I'm representing the lender? And do you want the tricky one that I'm a little bit embarrassed to use, or do you want the straightforward one? So and when you're signing an important document, you're the entrepreneur. You're the guarantor. This is you. Read it. Read it and understand it. Because if you don't understand it, then the jury definitely can't understand it. And the judge does not know anything about your business and had to become a judge because things weren't going so well at the law firm. Do you think the very best lawyers want to be judges? They really don't. I mean, I have a lot of friends who are judges who are great judges, and I have some friends who are judges that are not great judges. And you may end up with one of them. So you read the agreement. You make sure it's clear. Page 17, Respondeat Superior. So important tomorrow. You're responsible for what your employees do. Now, if you could make them independent contractors where they're not your employees and they actually operate independently of you, and especially if they're in India and China and not here, then you're not responsible. But if you're directing them and they are considered to be an employee, you're responsible for everything they do. So just keep that in mind, and if there's any issue, terminate them. Be more prone to terminate than to keep. Once you've seen those red flags and that person's done something that would cause you to not trust them with your home and your dog, then you really have to terminate them. Because we see over and over again that clients have ignored 10 red flags, and then something goes wrong caused by this person with the 10 red flags, and the client says, woe is me, such a surprise. That's, you've got to really hone in on these employees. They make or break us. We have 28 employees. I would trust all of them with the house, and my wife would trust most of them with the dogs, and she doesn't even trust me with the dogs. So, that's what we're going for. All right, dangerous instrumentalities, you're responsible if you own them. That's your guns, that's your three-wheeler, your four-wheeler, your jet ski, all that dangerous stuff. If anything goes bad, you're responsible. So, don't even buy that gun for yourself. That gun is your son-in-law's gun. That dog is your mother-in-law's dog. Just keep in mind, you can put vehicles into LLCs, and then the LLC is responsible as the owner. If you have employees who use your trucks or cars after hours, put those under an LLC. You're going to be responsible if the employee commits the negligence on the job, but when they go to the bar after the work and then on the way to the bar, from the bar to home, that's not your responsibility because they're an employee, but it's your responsibility if it's your truck. So you have to decide what you're going to do on that. Page 21, product liability. Everyone in the chain of title, just like hazardous waste, is responsible. So I rebuild a car. I sell the car to Jennifer. Jennifer sells the car to Tom. The wheel runs off the car. Jennifer's responsible. She didn't do anything wrong. She had no reason to know that wheel was coming off, but that's product liability. That's why a lot of times if you're a sales agency, you don't want to say, I'm buying the product from you and selling it to them. You say, you drop ship it, I'm your agent, I want my 9.2% on sales. I don't take title to these products, I don't guarantee these products. And a lot of small businesses do not have product liability insurance. If you're buying something from someone, and it may hurt someone, it may break, it may hurt you, it may hurt your business, get a copy of their product's liability insurance, and possibly even check up once a year for the product liability insurance. And you may be able to tag on your own coverage with their same carrier. So that's something a lot of you do have products. I didn't give pens today because I was afraid that my staff said, you can give everyone a pen. Well, what if somebody trips on a pen? Then they're going to call me and I'm going to have to represent them suing me because of a defective pen.